Did you know that filing for a green card after the age of 62 is one of the most legally complex and emotionally exhausting processes an immigrant can go through in the United States? And yet thousands of people every single year attempt to do it completely on their own, without any preparation, without any professional guidance, and without understanding the specific rules that apply to them, not to younger applicants, not to people in their 30s or 40s, but specifically to them at their age, at their stage of life, with their immigration history and their health situation and their financial picture. The rules are not the same. The stakes are not the same. And the mistakes you can make at 62 are far more costly than the mistakes someone makes at 32 because you simply do not have the same amount of time to recover from them. So before you walk into any immigration attorney's office, before you fill out a single form, before you pay a single filing fee, which by the way are not cheap and are almost entirely non-refundable if something goes wrong, I want to walk you through the 6 things you absolutely must do before you file for your green card at age 62. Think of yourself as the CEO of your own immigration case. You are not just a passive applicant, you are the decision maker. And the people you hire, the attorneys, the doctors, the financial consultants, they work for you. But you need to understand the terrain before you can lead them effectively. And I want to be very clear up front. I am not an immigration attorney. I am not giving you legal advice. What I am doing is walking you through the preparation framework that anyone navigating this process at this stage of life needs to think about seriously, so that when you do sit down with a licensed professional, you are not starting from zero. You are walking in informed, prepared, and ready to protect yourself. Let's start with the very first thing, and it is the one that surprises people the most. The first thing you need to do is pull your entire immigration history and audit it yourself before anyone else does. This sounds obvious. It is not obvious. Most people at 62 have a long immigration history. Visas, entries, exits, extensions, status changes, maybe a period where something lapsed, maybe a job change that affected a work visa, maybe a trip abroad that lasted longer than it should have. You have lived a full life, and your immigration record reflects that. The problem is that USCIS sees every single one of those entries and exits and status changes, and they will compare what they see to what you tell them on your application. If there is any inconsistency, even an innocent one, even one caused by a paperwork error 10 years ago, it can trigger a request for evidence, a denial, or in serious cases, a bar from re-entry. So before you file anything, you need to request your travel history from Customs and Border Protection. You need to pull any prior USCIS case records through a Freedom of Information Act request. And you need to sit down with that information and go through it honestly. Not defensively, honestly, because the goal here is not to hide anything. The goal is to know what is in your file before the government reminds you, so that your attorney can address it proactively rather than reactively. The difference between proactive disclosure and a discovered inconsistency is enormous in immigration law. One looks like transparency, the other looks like fraud. Even if neither one was intentional, the second thing you need to do, and this is especially critical at 62, is get a complete medical evaluation done before your immigration medical exam. Here is something that a lot of people do not realize. As part of the green card application process, you are required to undergo a medical examination performed by a USCIS-approved civil surgeon. That exam covers your vaccination history, your physical health, and your mental health. And at 62, you are statistically more likely to be managing a chronic condition, taking prescription medications, or dealing with something in your medical history that could raise questions during that exam. The civil surgeon is not your personal physician. They are not there to advocate for you. They are filling out a government form, and what they write on that form becomes part of your permanent immigration record. So what I am suggesting is that before you walk into that civil surgeon appointment, you go to your own doctor first. Get a full physical. Review your vaccination records and make sure they are complete, because if you are missing vaccines, you will need to get them, and some of them require weeks between doses, which will delay your entire application timeline. Review any medications you are currently taking with your doctor in the context of the immigration exam, because certain medications for certain conditions can trigger additional scrutiny. And if you have any history of mental health treatment, talk to your doctor about how that is documented, because the civil surgeon is required to ask about it, and you want to understand what your records say before someone else reads them out loud to you in an official context. None of this is about hiding anything. All of this is about walking in prepared. The third thing you need to do is have a serious and detailed conversation about your financial sponsorship situation. One of the most common reasons green card applications for people in their 60s fail or succeed but cause enormous family stress is because the financial sponsorship piece was not thought through carefully. In most family-based green card cases, you need a sponsor who can demonstrate income at or above 125% of the federal poverty guidelines for your household size. If your sponsor is a family member, a child, a sibling, a spouse who's already a U.S. citizen, that person needs to understand what they are signing when they sign Form I-864, the Affidavit of Support. That form is a legally enforceable contract. It does not expire when you get your green card. It does not expire when you become a citizen. It expires when you have worked 40 qualifying quarters under Social Security, which at 62 is highly unlikely to happen quickly, or when you die, or when your sponsor dies. That means if you receive any means-tested public benefits during that time, the U.S. government can go after your sponsor to recover those costs. That is not a hypothetical. That is the law. So your sponsor needs to understand that before they sign, not after. And you need to understand it too, because your relationship with that sponsor is going to be tied to this legal document for a very long time. Sit down together. Review the numbers. Make sure the sponsor's income is genuinely sufficient and not just barely crossing the threshold on paper. And if there is any doubt, look at whether a joint sponsor is needed or whether assets can be used to supplement the income calculation. The fourth thing you need to do is understand the specific green card category you are filing under and whether there is a faster or more strategic path you have not considered. At 62, most people filing for a green card are doing so through a family-based petition, typically an immediate relative of a U.S. citizen, which carries no numerical cap and therefore no waiting line. If that is your situation, you are in the most favorable category available. But if you are not an immediate relative, if you are a preference category beneficiary, meaning a sibling of a U.S. citizen or an adult child, you may be looking at a wait time that is measured in years or in some cases decades, depending on your country of birth. And that changes the entire calculus of your situation. Do you maintain your current status while you wait? What happens to your ability to work? What happens if your health situation changes and you need access to U.S.-based health care during the waiting period? These are not questions to answer in the attorney's office when the clock is running and the filing fee is already paid. These are questions to answer before you even open the process, so that you are making a strategic decision about timing and category and pathway rather than just reacting to your circumstances. There are also employment-based and investor-based pathways that some people at 62 qualify for and never think to explore. The point is not that every path is available to everyone. The point is that you should understand every path that might be available to you before you commit to one. The fifth thing you need to do is think through your tax and benefit situation carefully, because becoming a lawful permanent resident has financial consequences that most immigration attorneys will not walk you through in detail because that is not their job. It is the job of a CPA or a financial planner who understands the intersection of immigration status and tax law. When you become a U.S. green card holder, you become a U.S. tax resident for federal income tax purposes. That means you are required to report your worldwide income to the IRS, including income earned in your home country, income from foreign bank accounts, foreign investments, pensions, and any other assets you hold abroad. There are reporting requirements, FBAR, FATCA, that carry substantial penalties for non-compliance, and they kick in the moment your status changes. If you have spent decades accumulating savings or property or pension rights in another country, you need to sit down with a CPA who handles international tax matters before you file for your green card, not after, so that you understand what disclosures you will need to make and what tax planning opportunities exist before your status changes. This is also the moment to think about how your green card status will interact with Social Security eligibility, Medicare eligibility, and any other federal benefit programs you may hope to access as you move into your later years. The rules are complex, the waiting periods vary by program, and the decisions you make now about how and when to file can affect your benefit amounts for the rest of your life. The sixth and final thing you need to do, and this is the one that ties everything together, is build your team before you file, not after something goes wrong. Immigration at 62 is not a solo project. It is not something you hand entirely to an attorney and then wait for results. It is a coordinated process that involves legal strategy, medical preparation, financial documentation, tax planning, and emotional readiness. The attorney handles the legal forms and the strategy. The civil surgeon handles the medical exam. The CPA handles the tax and financial disclosure piece. Your sponsor needs their own understanding of what they are committing to. And you need someone, a trusted person in your life, who can help you stay organized, because the documentation requirements for a green card application at this stage of life are extensive. Birth certificates, marriage certificates, divorce decrees if applicable, police certificates from every country where you have lived for more than a certain period, tax returns, pay stubs, financial statements, vaccination records, passport copies, photographs. The checklist is long, and missing a single item can result in a request for evidence that adds months to your timeline. So get the team in place, get the documentation organized, and do not walk into the filing process reactive. Walk in prepared. Here's the bottom line. Filing for a green card at 62 is absolutely possible. People do it every single year and they succeed, but the ones who succeed are not the ones who rush. They are not the ones who hand everything over to the cheapest attorney they could find online and hope for the best. They're the ones who treated this process like the serious, life-changing legal and financial event that it is. They audited their own history first. They prepared for the medical exam on their own terms. They had honest conversations with their sponsors about what the affidavit of support actually means. They understood their category and their timeline. They talked to a CPA before their status changed. And they built a team that could support them through every step of the process. You are 62. You have worked your entire life to get to this point. This green card is not just a document. It is access to stability, to healthcare, to the ability to stay close to the people you love for the rest of your life. It deserves your full attention, your full preparation, and the right team behind you. Do not rush it. Do not cut corners. And do not try to do it alone. If you found this helpful, share it with someone who is going through this process right now, because I promise you, there are people in your life who need to hear this before they make a very expensive and very stressful mistake. And if you want to go deeper on any of these steps, leave a comment below and let me know which part of the process you want me to cover in more detail. I read every single one.